Good evening. This is Making the Case. I'm Yodit Tewolde. Day 3 of testimony wrapped in the murder trial of Gregory McMichael, Travis McMichael, and William Bryan, the 3 white men charged with killing Ahmaud Arbery. So far, we've heard from several current and former Glynn County police officers who were among the first to arrive at the scene of the shooting. Today, attorneys focused on what Gregory McMichael had to say moments after the shooting. BNC's Dre Clark is outside the courthouse in Brunswick, Georgia, with the latest.
Prosecutors say Ahmaud Arbery was killed because of 3 white men believing that a young black man running through their neighborhood must have been running because he committed a crime. And today in court we learned those 3 men had never seen Ahmaud Arbery steal anything. Ahmaud Arbery was casually jogging on a sunny afternoon until he crossed paths with Gregory McMichael. McMichael said he recognized Arbery as a neighborhood burglary suspect, so he and his son Travis grabbed their guns, hopped inside a pickup truck, and chased Arbery. Detective Parker Marcy interviewed McMichael. He was asked to read from his notes.
I'll be quoting him. He says, "Well, I'm thinking he's either done something to somebody's chasing him, or, I thought, well, maybe somebody drove up and found him in their house."
McMichael said Arbery had been seen on security video multiple times walking around a neighborhood house under construction. But McMichael told Marcy the guy seen on video had never stolen anything from inside the house. Still, McMichael believed Arbery might be armed and dangerous, and he was going to make a citizen's arrest.
Did he indicate at this time what he thought the guy should be arrested for?
No, ma'am.
All right. Didn't say burglary?
No, ma'am.
Didn't say criminal attempted burglary?
No, ma'am.
Didn't say trespassing?
No, ma'am.
McMichael said he yelled at Arbery to stop, but he kept running. The McMichaels were in one truck, and their neighbor William Bryan was in his vehicle chasing Arbery and recording it. They didn't stop until they had Arbery cornered. Again, Detective Marcy reading from his report.
The guy was cornered. He was cornered like a rat.
Cell phone video shows Arbery trying to desperately get away, but Travis McMichael shoots him with a 12-gauge shotgun. As Arbery was on the ground dying, Gregory McMichael said he moved one of Arbery's arms to make sure he didn't have a gun. Jeff Brandenberry was one of the first officers on the scene. He recalled what McMichael told him about the shooting.
To be perfectly honest with you, if I could have got a shot at the guy, I'd have shot him myself, because he was that violently, and then we were interrupted again.
Prosecutors say Ahmaud Arbery wasn't a wanted man. He never stole anything. He was a victim, they say, of 3 overzealous white men who assumed a black man running must be a criminal. Inside the courtroom today, Judge Timothy Walmsley admonished one of the defense attorneys, Jason Sheffield, saying to Sheffield, "You need to reconsider how you're conducting yourself in this courtroom." He said to Sheffield, "I don't care if you like me or not, or my decisions, but you will respect the court." Judge Walmsley was so frustrated, he had to call for a recess. Meanwhile, Reverend Al Sharpton will be here in Brunswick, Georgia tomorrow for a prayer vigil. He'll be meeting with Ahmaud Arbery's family, and then they will pray together on the courthouse steps. In Brunswick, Georgia, I'm Dre Clark for Making the Case.
Now it's time to bring in my legal panel of experts to weigh in on the evidence the prosecution presented today. From San Francisco, veteran prosecutor and BNC's legal contributor Paul Henderson, and in Houston, criminal defense attorney Adanté Pointer. Glad to have you both. Let's get started with the first prosecution witness called to the stand this morning. Take a listen to the prosecution's direct examination of Officer Jeff Brandeberry, one of the officers who initially interviewed Gregory McMichael at the scene.
Did Gregory McMichael ever indicate to you at that time that he thought Ahmaud Arbery, the guy, had committed a crime that day?
No, ma'am.
So he didn't say the guy committed the crime of this?
No, ma'am.
And when he said to you that numerous occasions the guy has broken into a house over there, they've got him on video, what house was Gregory McMichael talking about?
A house down the road that was under construction.
Okay, so he's not talking about his home at 230 Satilla Drive?
No, ma'am.
All right. While speaking with you, did Gregory McMichael ever use the word burglary?
No, ma'am.
Did he ever use the word trespass?
No, ma'am.
Did he ever tell you while you're talking to him that he was attempting to make a citizen's arrest?
No, ma'am.
Paul, Gregory McMichael was a former officer and an investigator with the district attorney's office, yet he never indicated to this officer what led to the shooting, that he believed Ahmaud committed a crime that day. And when Gregory McMichael talked about those break-ins on, quote, numerous occasions, he wasn't talking about his own home, never used the words trespass, burglary, or citizen's arrest. Why is this important for the prosecution to point out for the jury?
Because it proves and shows that he had no basis for stopping him, for chasing him, for attacking him, for using his gun. And then what stood out to me, even just from the clip that you showed just there, and I watched the full testimony this morning as it came out, the prosecution was treating that witness, the officer, as a hostile witness. And I think if you listen to the tone, the delivery, the questioning, it's almost like a cross-examination. And this is really a fine point that I think we have to pay attention to while we're examining and pulling out the evidence from these officers, is that they are not friends of the prosecution and how the evidence is being presented because of their own mistakes and the privilege that was bestowed upon these defendants in this whole case. And so it's difficult for the prosecution to pull out this information that's going to be helpful for them to use against these defendants. But that's exactly why those questions and those answers matter, because they invalidate the self-defense claim that they're making, and they invalidate the basis from the defendants that Ahmaud was dangerous, that he had committed a crime, that they knew he had committed a crime, which he did not. These were all just suspicions that they self-validated to attack him, to chase him down, and to shoot him and kill him.
Well, take a listen to more of what Brandeberry testified concerning what Greg McMichael said that day.
And you asked him, so you heard 2 shots.
Mm-hmm.
What does he indicate?
He said he saw him.
Okay. And then lines 6 through 9. What did he say then?
I saw him, yeah. In fact, if to be perfectly honest with you, if I could have got a shot at the guy, I'd have shot him myself, because he was that violently. And then we were interrupted again.
And you were interrupted again?
Yes, ma'am.
Okay. Now, the person who interrupted you at this time, was this a law enforcement officer?
I don't believe so, no, ma'am.
Okay, it's just some bystander stranger who walks up.
Yes, ma'am.
All right. Now, Officer Brandeberry, second day back on the job, right? You have a cold. Did you allow this strange person to come up and start talking to Greg McMichael?
I did.
All right. So at any point in time, was Greg McMichael isolated from speaking with any of the other parties there?
No.
Was he told to sit on the curb and don't move?
No.
Was he put in the back of a patrol car?
No.
And so some strange guy just comes up to him and starts talking to him?
Yes, ma'am.
All right. And you didn't stop him or tell him to go away?
I did not.
Okay.
Adanté, there was a shooting. There was a body laying on the ground. Yet Gregory McMichael was able to have multiple conversations with law enforcement and bystanders, go where he wanted. Why was it important? I mean, I guess that's to Paul's point. There were mistakes made by law enforcement that day. So is that what the prosecution is trying to point out to the jury in this moment? Or are they trying to just illustrate how Gregory McMichael was given sort of a leeway, maybe because of his law enforcement background?
I think it's both. You know, I think that a typical experience that we either see, whether it's watching TV or watching the movies or whodunit mysteries, the criminal suspect is isolated from other witnesses and they're immediately sequestered, whether that's in handcuffs, you're sitting on the curb, you're in the back of a patrol car. Never in our common experience do you think that someone who is suspected of, even if maybe not a crime has been determined, but definitely had a hand in the death of someone, a shooting death of someone, would they be allowed to be freely just walk around the crime scene and interact with people? So I think it served two purposes, if you will. One purpose of which to show that this McMichael was given leeway, but also to show that law enforcement was giving him the type of benefit of the doubt and preference that most people would never enjoy if they found themselves in that position.
Well, counsel for Gregory McMichael, Frank Hogue, cross-examined Brandeberry. Take a listen to this.
You have your transcript up there of your
I do.
body cam. Let's go to page 6, line 6. And while you're getting there, Mr. McMichael actually went through the story with you 2 or 3 times.
Several times, yes, sir.
Right. And we were looking at one of those times when he went through it just now with the state on direct, right?
Yes, sir.
But he had already told it to you once before, and he even told it to you another time.
Again, yes, sir. He told me several times.
And in part that was because of the interruptions that were occurring, and you had to stop and start.
Yes, sir.
Okay.
The other part of that was for clarification purposes.
Right. And that's a police technique, have somebody tell the story a couple times, see if it stays the same.
Yes, sir.
His stayed the same.
Objection.
Paul, defense counsel there made the point to point out that Gregory McMichael had told the same story in that moment to this officer and stayed consistent the entire time. You can tell the same lie over and over again, can't you? I mean, did the defense, though, make an effective point? And why the objection from the state?
Yeah, I don't think they made an effective point. It infuriated me, and Yodit, I feel like we just keep coming back to this again and again while we're cross-examining law enforcement. The privilege that we are seeing unfolded here in this case as how law enforcement treated these defendants. Because the other thing with this exact defendant that we went into when they first started questioning him was that how he submitted his report based on the testimony and based on the confession and the statements by these defendants, that his entire report was 1 page and a paragraph. Now, I've been a prosecutor a long time, and that's about the amount of dignity that you would get a shoplifting or jaywalking. I've never seen a homicide that was a 1-page summary. And so even if that defendant told him that story several times, notice what's missing is his following up from when he was interrupted by a bystander talking to the defendant. Notice how there weren't difficult questions where he asked specifics about what he saw and observed with a black man dead in front of him and 3 white men standing around with blood and a gun in their hands. This is the issue. So no, I don't think he made a valid point, at least not to me. And I'm hoping that prosecution, they rightly made the objection. And I'm hoping that they circle back around to point out these same things in conclusion at the closing that I noticed during this testimony from law enforcement. Again, it's a real balance because you don't want to shift too much of the jury's attention to the inadequacies that are measured and complete with law enforcement in this case. You want to keep the attention focused on the 3 defendants and what they did, but it's infuriating listening to this as a prosecutor to hear law enforcement testify so badly about their proven and given shortcomings in this case and the privileges afforded these defendants. I know I got on the roll, but...
All right, guys, here's more cross-exam of Brandeberry by defense counsel Frank Hogue.
He says, this guy, whom we've seen on video numerous times, breaking into these other houses, he comes hauling down the street. I mean, he's got it hooked up. That's what he said to you?
Yes, sir. That's accurate.
And again, when he said breaking into these other houses, later on in your synopsis, as it was characterized, your report, you wrote in it that Mr. McMichael reported to you that he believed this guy had been breaking into houses in the neighborhood, right?
Prior, yes.
Adanté, on direct exam, the prosecution made sure to point out what Gregory McMichael didn't say, but on cross-examination, the officer testified that Gregory McMichael mentioned that he believed Ahmaud had broken into houses in the neighborhoods in the past. Does that matter if Gregory McMichael couldn't say whether Ahmaud broke into one that day in order to make a lawful citizen's arrest?
I think this is all based upon assumption and speculation. You know, essentially because he saw Ahmaud Arbery running down the street, a black man running down the street, he was instantly a suspect and then a defendant and then a righteous kill from their perspective. And so, you know, claiming that there was some break-ins happening of which you have no real personal knowledge about, committed by someone who you yourself have not identified as being the person doing those break-ins, and then none of this happened to you, but because it happened somewhere out in your community, you take it upon yourself to do some type of vigilante justice. At least that's what you're telling the police is your justification for hunting down, stalking, and then shooting and killing Ahmaud Arbery. You know, they had to reach for something, and to me, it was a pretty flimsy defense. It doesn't stand up when you put it under scrutiny.
All right, Paul, Adanté, you two are staying with me through the hour as we go through more testimony in day 3 of this trial. We'll be right back with more Making the Case. We're continuing our coverage of day 3 in the trial of the 3 white men accused of murdering Ahmaud Arbery. Still with me, Paul Henderson, veteran prosecutor and BNC's legal contributor, and Adanté Pointer, criminal defense attorney. All right, guys, let's talk about the second witness who testified today, Detective Parker MARCY, an investigator for the Glynn County Police Department. He was one of the first on scene and spoke directly to Travis and Greg McMichael. During his testimony, prosecutors played surveillance footage showing Arbery walking around a construction site moments before he was shot and killed. Here's some of that now.
Now publishing clip 1. Is this substantially how you found the interior when you went there?
Yes, ma'am.
And what is Mr. Arbery doing in clip 1?
Walking around looking inside the construction.
And then the rest of this particular video, do you see him take anything or steal anything from this location?
No, ma'am.
Paul, investigator MARCY testified that he didn't see Ahmaud ever take anything. So if he didn't see him take anything, and everyone else can clearly see from the video that Ahmaud didn't take anything, then how could these 3 defendants make a lawful citizen's arrest over something they couldn't have seen?
Exactly, that part. They tried to make a lawful citizen's arrest, which is not legal, because they presumed that he had done something bad. The other thing that stands out to me, even in just that clip, you know what I see? That he doesn't have a bag. You know what I see? That he doesn't have a weapon. He didn't even have a wallet. He was walking around as other people had walked around inside that site, but because he is black, these defendants presume that not only had he stolen something, but that he was a criminal and he was associated with other past thefts as well, even though they counteracted their own testimony with all of that. This video that they're showing right now that you just showed is confirmation of what we all know, is that they enacted their chase, that they ran and got their gun, and that they acted aggressively, specifically and purposefully because of race, because of their presumptions, because they wanted to, and it was unwarranted. That's why this video is so important. Everything was based on a lie, and this undermines the approach that they're taking in the first place, that you'll hear more about later in their case, about self-defense, because they created this confrontation that was not based on anything valid, on anything legal, or on anything tangible, as we've seen from the video that confirms that.
And if citizen's arrest falls apart, then naturally self-defense does too, right? On cross-examination now of this witness by the defense, let's take a listen to that. And Adanté, I'm going to get your thoughts on the back end.
All right. So once you got the information, Greg expressed to you his belief that Mr. Arbery was committing thefts inside that home.
Objection. That is not what Greg McMichael said at all. And paraphrasing this is inappropriate. Either specifically what Greg McMichael said, but to paraphrase it this way is outside. That's for the jury to determine.
Adanté, Detective MARCY had testified that when he asked Gregory McMichael if the neighbor's video showed Ahmaud stealing, Gregory McMichael said that he didn't think he actually stole anything, or if he did, it was early on. Here, the defense was suggesting that Gregory McMichael's statements was about Ahmaud's alleged criminal activity on February 23rd of 2020. Was that a good catch by the prosecution?
I don't think that, I mean, it was a good catch by the prosecution, but what actually caught my attention in that clip is the defense actually drew more attention to, in my opinion, a weakness in their defense by drawing the jury's attention with that long-winded speaking objection, which judges often would not allow you to get that many words out of your mouth, but actually allowed the defense some leeway, I think it showed and proves up the point that, look, we watched the video, you don't see anything criminal acts taking place there, and because you're reacting in that way as a defense, to me, it shows that you're afraid of what that video actually shows and the way in which the jury would look at that video and interpret it in the righteous way it should, which is that this young man did not do anything wrong. He merely stepped on some property, looked around, and as Paul just said, he didn't have a bag with him. He didn't have a weapon. You don't see him picking up items and seeing if they'll fit in his jogging shorts or anything like that. So, I think the defense made a major faux pas by drawing more attention to a hole in their case than they did by trying to offset the points that they thought the prosecution made by playing the tape and their line of questioning.
Okay, I got a quick question for you both. Because I'm thinking about all this, how can the defense be effective in their cross-examination of these witnesses when there are 3 defendants with at least 2 lawyers representing each of them? Can jurors keep track of which lawyer is making what point for which defendant? I mean, are they at a disadvantage having a joint trial? Paul, to you.
I don't think so. I think they have a cumulative effect of trying to really inundate this jury with their perceptions of fear, with their perceptions that were in speculation about this ominous black person that they saw in their neighborhood. That's the picture that they're trying to paint. And I think they're all working collectively to try and make sure that the jury understands how reasonable it was that they had these suspicions, how reasonable it was that they had to take action, and how reasonable it was that they should be afraid and take aggressive action to keep someone like Ahmaud Arbery, translation, a black person, out of that neighborhood and in their environment. That's, I think, the goal, because they don't have a real defense here to stand on, not legally and not based on the evidence.
Adanté, your quick thought.
Yeah, I mean, I think a case of this magnitude, with this high profile, these attorneys should have coordinated and figured out what their line of questioning would be. And if there's a unified point that they think will benefit all of them, then each one will stand up and try to reiterate it, if only to just beat it in the jury's head. The effectiveness of that, we'll see. But I understand the point and the strategy of what they're trying to do. The question is there so much on the other side that even if you make 1 point, you're already down by 100 points by the weight of the actual evidence, as opposed to the innuendo that you're trying to bring in front of the jury.
All right, guys, we're up on another break, so stay tuned because we continue our trial breakdown of day 3 when we return. Welcome back to Making the Case. Picking up where we left off in our trial breakdown of day 3's testimony in the murder trial of 3 white men charged with murdering Ahmaud Arbery. Veteran prosecutor and resident legal contributor Paul Henderson and criminal defense attorney Adanté Pointer still with me. All right, guys. So there was quite a bit of legal maneuvering today, which seemed to frustrate the judge at times. We've got a clip of one of those moments where the judge goes in on one of Travis McMichael's attorneys, who at the time was cross-examining Detective MARCY. The prosecution had all these objections that they made, to which the defense counsel expressed his frustration. That's when the judge sent the jury out of the courtroom, and watch what happened next.
Mr. Sheffield,
Yes, sir.
you can agree or disagree with this court. That is your prerogative. But to act in the way that you just did in front of this panel, disrespect, I don't care whether you like my rulings or not, or you like me or not, but in this court, the Superior Court, it is axiomatic that counsel show at least respect for what the court is doing. And what you just did shows a lack of respect for what the court is trying to do here, which is create an environment which is fair to all parties. I would suggest that you take a moment to think about that. I'm going to step off the bench because I found that, I'll just call it rude.
Adanté, that moment reminded me of a time when I was in trial, and I too got into some trouble with the judge who called me up to the bench to basically reprimand me too, because I was making my frustrations known to the jury about the prosecution's line of questioning. It was more about strategy than not being able to control my own emotions. I mean, as you know, the prosecution's table is closer to the jury, and that makes it harder for the defense to connect with the jury. So I had to turn up the antics to make sure they knew what I was thinking. Do you think that here, listen, the jury are the fact finders, right? But the judge has control in terms of which direction this trial is going to go in. He's going to either sustain or overrule the defense's objections. Bad start for the defense, correct? To get on this judge's bad side?
I think so. I mean, you never want the judge, the person who could put their thumb on the scale, if you will, and kind of tilt the way in which the trial is going, to be against you. However, having been known as a very passionate advocate, I certainly have run afoul and have rubbed some judges wrong. But in the pursuit of justice, sometimes that's what happens. We all know that it's not necessarily a fair game from beginning to end, and this trial hasn't been fair. Nevertheless, when you're playing from behind, as I think the defendants are as it relates to the evidence, but yet they want to show the jury that my client can't get a fair break here. This thing is all slanted to go towards a conviction, and I'm fighting for justice, then sometimes those antics will actually pay off. I think it's a long shot, and it's a very risky bet. The type of bet that, pays off 1,000 to 1 if you're in Vegas, but the likelihood is that the house is going to take your money. And that's exactly what the judge told that attorney. I'm going to take your money and take you to the woodshed.
Well, let me just say that my antics worked because I won that case. Paul, your thoughts on the judge's admonition of this attorney. I mean, clearly he's rubbed this judge the wrong way or the defense has from the very beginning. But what do you think that means for the jury? Do you think that they're liking their client less due to those antics?
Well, one of the things that I think the judge did them a favor by clearing them out before he commented and not making a side comment or a direct comment while it was happening in front of the jury, as he could have done in this case. But I think what the judge is pointing out in this case, and listen, it's a fine line when you are in the heat of the battle of a trial. And as you can imagine, I am somewhat animated and passionate about my cases, regardless of the side I'm sitting on as well. And so this ruling in an order from a judge that I too have heard in the past. But the issue here in this case and for this trial is that behavior is not only disrespectful to the court, but it is disrespectful to Ahmaud Arbery as the victim in this case. And from a broader context, it's disrespectful to the audience that is watching this case, that is in the courtroom, that is filled up with Ahmaud Arbery's family and Ahmaud Arbery's community, which is all of our community. And so it's magnified with the offense. And so he should be walking a straighter line moving forward, because these antics would be and could be a distraction to everyone in that courtroom. And that's a problem. So I'm glad the judge said something.
All right, so quick question, because I love placing bets, but this trial is expected to go, I think, a day before Thanksgiving. I'm guessing that at this rate, with all of the objections that are made, with all of the excusing of the jury out of the courtroom so that they can talk, this is going to go well into December. Your thoughts, Adanté? How long do you think this trial is going to last?
Well, most trial attorneys think they can get the work done much quicker than they can, especially when you get into the weeds. So I could see this trial definitely going into December and dragging out, because things take place. I mean, we have the holidays going on. Anything can happen with a juror. There's delays. If the defense takes up the position which they've been doing, which is making and filing a bunch of motions to try to either slow down the jury or break the momentum of the prosecutor in terms of their presenting their case and the evidence, then this case can stretch out. And on top of that, if I'm a defense attorney, and I don't want the jury getting this case right before they get to sit down with their family and enjoy their family and eat turkey and watch football or whatever else they do and talk about how much they love their family, when I then have to tell them, hey, I'm a jury on this case where this young man doesn't get to be with his family. So I'd want to stretch it out so that the jury gets the case after the Thanksgiving holiday, but well in advance of Christmas, where people once again start thinking about their family and how much they love and otherwise might miss the family members that aren't at the table with them.